Hi, good morning, everyone. Thank you for joining. It's great to see so many people from around the world. My name is Scout Moran, and I'm very excited for our discussion today. We will dive into the AI regulatory landscape and discuss what it means for leaders trying to innovate quickly with AI while protecting their company brand, customers, and security. We will get started in just a minute. Before we do, a little bit of housekeeping. Because of the size of the webinar, all attendees are automatically muted. To enable closed captioning, click the CC button at the bottom of your webinar window, which is pictured here. We would love to hear from you throughout the session, so please leave comments in the Q&A widget. We have the team working behind the scenes to help answer your questions. And do not worry about taking notes. We'll follow up with a recording of the event so you will not miss a thing. Now, we will cover a lot of ground today. We have a variety of folks joining us across technical and non-technical roles. So we will break down what is most important broadly, as well as touch on areas where unique considerations need to be made. First, we will talk about the evolution of AI regulations, highlighting the similarities and differences from existing laws. Then we will walk through core concepts that leaders need to know to keep top of mind to maintain a holistic compliance practice. Lastly, we will give you a peek into Grammarly's compliance journey so you know what to look for as you evaluate and monitor your AI vendors and applications. As a reminder, I am a lawyer, but this is not legal advice. My goal is to provide you with a broad framework for you to take back to your companies to dig further. So let's introduce ourselves. As I mentioned, I'm Scout Moran. I'm Senior Product and Privacy Counsel at Grammarly. I work with our engineering, product, and design teams as they're developing new features and guide them toward compliance with relevant laws, particularly those related to data privacy and Gen AI. I am joined today by my colleague, Alan Luck. Alan, please introduce yourself.
Hey everybody, I'm Alan Luck, head of GRC at Grammarly under the broader security org. The GRC team creates policies and procedures to ensure all our employees do their work in a manner that's compliant with regulations and industry standards, such as our engineers who develop our products. And we also manage Grammarly's audit certifications, such as ISO, SOC 2, PCI, HIPAA. And finally, my team's also a key reviewer for conducting third-party vendor reviews, including those with AI capabilities.
Today, Alan and I will take turns representing both the provider and deployer perspectives of AI compliance to help you understand what's required as you adopt AI across your organization and functions. In particular, we will highlight what you should expect from vendors you're evaluating to ensure they meet your standards for responsible AI and compliance. Grammarly has been both a builder and buyer of AI technology for the past 15 years, so we'll be sharing the learnings and perspectives that we've uncovered from this experience. To kick things off, Alan, why don't you set the stage for why this is such an important topic right now?
Absolutely. First off, we'd have thousands of people register for this webinar, so this is clearly a hot topic right now. What's unique about AI and specifically Gen AI is just how far it's spread across orgs and the speed at which it did so. Almost every company, function, and role is now using some form of AI regularly. A lot of this adoption is driven by people using AI tools on their own, which kind of is creating a security and IT nightmare if you're familiar with the term shadow AI. And because of this, leaders need to be aware and incorporate them into their enterprise AI strategies. Many teams are now piloting larger scale AI programs to unlock productivity, but also have to understand how to protect the enterprise while doing so. On this screen, this only shows a fraction of the teams using AI and a few of their use cases, but all of these AI apps are pulling from a data set, running through LLMs, and therefore falling under the scrutiny of regulatory considerations. So, responsible AI and AI compliance is not just something CISOs, legal, and compliance folks need to care about. But really, every leader across the organization should understand what data is being used to train models, how those models interact with data, and how each of the many apps teams are using tap into both. While we won't go into the details of specific use cases, we'll give you enough working knowledge here today to know what the key considerations are.
So, moving on to the evolution of AI regulations, there's a lot of buzz right now about the EU AI Act. But first, let's back up a step to discuss how we got here. In 2018, the GDPR came onto the scene. One of the key goals of the GDPR was ensuring that big American tech companies treated personal data of European residents fairly and transparently. After that, California and later a number of other US states adopted similar data protection laws. The CCPA, for example, has many of the same key concepts around data collection, use, and retention as the GDPR. And I flagged those two foundational laws because today's AI regulations draw on a number of core provisions from the GDPR, particularly around fairness and disclosure. Moving forward, you can see that several agencies in the US have become interested in regulating AI. In particular, you have probably heard about the US Executive Order on Safe and Secure AI, or the Biden Executive Order. Now, that is not a regulation, but it provides guidance for agencies to enact regulation. Next, we have the EU AI Act, which we will discuss in detail. And finally, we listed a draft state bill on this timeline that's under review right now. This particular one is getting a lot of discussion on Twitter right now. Keep in mind that a couple dozen states are considering passing AI-related legislation as we speak. Now, most of the people on today's calls are not attorneys, although maybe you've binged all of Suits and you fancy yourself a lawyer. Alan, can you talk a bit about how business teams can put these laws to practice?
Yeah, so while interpreting these regulations may come second nature to, folks like Scout, I'm not a lawyer. Most other teams like security and compliance need some help translating them into business and engineering requirements. And that's where the frameworks and standards come in at the bottom of the graphic. The first one is NIST, which is the National Institute of Standards and Technology, a U.S. federal agency that's been around since 1901, dedicated to creating guidance on security, privacy, compliance, and risk management for public and private industries. In early 2023, they came out with the AI Risk Management Framework for orgs to assess whether they've identified risks associated with AI, specifically the trustworthiness considerations in designing, developing, and using AI products. ISO is the International Organization for Standardization, a non governmental organization that develops global standards to ensure products and services are safe, reliable, and of high quality. Also, in early 2023, they came out with their guidance on AI risk management, which is very similar to the NIST AI RMF. And then finally, in late 2023, ISO published the world's first AI management standard, which is also certifiable, meaning an organization can get audited by an independent third party to prove compliance and that they're meeting the requirements.
Thanks, Alan. So turning toward the EU AI Act, or the AIA. Now, I have good news and bad news on the AIA. Let's start with the bad news first. The AI Act is already in effect. I apologize if that is a rude awakening to anyone. But the good news is that the due dates for compliance are fairly far out in the future. So within 6 months, companies need to confirm that they do not have any prohibited uses of AI. And within 6 to 18 months after that, companies need to tackle some of the other core requirements, particularly around disclosure. So what's the AIA all about? I think of the AI Act as setting a floor for future regulation, and individual countries may choose to be more stringent. The EU is trying to set a floor for safety. So, in the same way that they would regulate safety in airplanes and legislate around making sure that no planes are going up in the sky that have not met safety standards, The EU wants to similarly make sure that AI is being deployed safely. The AI Act ensures that there will be quality assurance. AI will not be put on the market if it's not safe, and it can be pulled off the market if it falls below the requirements. So, to get at this safety requirement, companies need to show that they do not have prohibited uses of AI, and where their use of AI constitutes high risk, they must document it carefully and make certain disclosures. Turning from the AIA to US state laws, you can see on this map that a number of states have either passed AI regulation already or they're considering draft bills. At first, this may seem a little overwhelming. For example, if you're not looking for a new time-intensive hobby and tracking emerging AI legislation, but fear not, we are already seeing some core concepts emerge across state laws. For example, we see requirements for clear disclosures relating to AI interaction so that people understand when they are interacting with AI and not humans. Also, there are bills giving data subjects the right to opt out of using their personal data for model training. So we will continue to monitor this space to see which bills actually make it to law, but hopefully it will be a similar exercise around tracking state data privacy laws where we see a lot of variations on the same theme. So with that background, let's discuss how we use our learnings from these existing regulations when you want to procure AI for your company. There is a three-step framework that I keep in mind based on the core concepts of Gen AI regulations. I will highlight the broad concepts and turn it to Alan to showcase how to put this into practice. The first of the three-part framework is identifying your goes and no-goes. If you are bringing an AI service to your organization, start with identifying the most critical go, no-go decisions. In other words, what is the bottom line that you won't go forward with if you cannot get a commercial term in your enterprise contract? First, cyber issues. If a vendor is not SOC 2 compliant, or if they cannot meet the general procurement standards around cybersecurity, that's an obvious no-go. Next, decide your stance around training on data. For some companies, this is a really significant issue. And whether this is important to your company depends on whether there is any inherent sensitivity in the data. So, for example, if you are in the financial services space, you may care very deeply about this. On the other hand, maybe you use AI for email marketing, and this is lower risk for you. Third, and finally, ask if employees of your vendor can view your data. This is usually known as eyes off, and it's gained a lot of traction recently. The good news is eyes off is typically incorporated into an enterprise license, but always ask if and when data that you share can be accessed easily by vendors' employees. Now, once you have your go, no-go decisions made up, do your diligence around the data flow and architecture. And for what it's worth, you already likely ask similar questions in your general vendor onboarding process. First, workflow. It's important to understand the flow between the vendor and the LLM provider. Ask about the technology stack. Is it designed to be confidential and protected? If your data is particularly sensitive, can it be segregated from other customer data? Second, what protections are in place to keep data secure? Is the data you share encrypted? Is it encrypted in transit and at rest? Is it deleted? Third, what is the relationship that the vendor has with their LLMs? Your vendor terms are only as good as their terms with the LLM provider, so really pressure test this. And the most straightforward way is to ask whether your vendors have an enterprise level agreement with their LLMs. You might be surprised. So, Alan, can you please tell us about how this process works at Grammarly?
Yes. So at Grammarly, several teams are involved with third-party vendor reviews, such as procurement, privacy, compliance, security, legal, and IT. When a vendor has an AI product or feature, we also bring in our responsible AI experts. And the process begins with having the vendors fill out our general questionnaire, which includes all of the go, no goes, and data flow and architecture points Scout described earlier. Data training, we want to understand things like how both they and the third party LLMs they're building off of are training their models and what data that's based off of. Data quality, we want to know how they're testing the output of their models and their benchmarks for ensuring high quality. Data minimization, we want to know if they're intentional in only storing data needed to deliver the services and minimizing sensitive information as much as possible. Data retention, we want to make sure they're not storing everything just to have it, and there are defined retention periods that justify how long they need it. Data privacy and security, this is all the good stuff you usually see in security certifications, such as ISO and SOC 2, related to securing and protecting user data like encryption controls, access controls, vulnerability assessments, penetration testing. And finally, compliance. Does the vendor have the security certifications that serve as the proof points of having a mature security, privacy, and compliance program instead of just kind of saying so by themselves? When an AI product or feature is involved, we bring in our responsible AI experts into the review process. The traditional security, privacy, and compliance focus areas are usually not enough since they don't directly look at the AI risks and certain characteristics of AI trustworthiness. So these types of questions are geared more towards AI, risk monitoring. We want to know if the vendor has included AI risks in their overall risk management program. Transparency and explainability. Since most AI systems are kind of like a black box with sometimes huge implications, all the regulations require transparency and explainability of the models so users understand why and how the output was given. Performance and accuracy, similar to data quality on the previous slide, we want to know what metrics they're using to measure the performance and accuracy of the models. Bias management, we want to know how they're testing their models to prevent bias in model output. And this also goes back to data training. Like what data sets are being used to train the models? Is it representative, diverse, unbiased? And ethical considerations. What mechanisms are in place to prevent harmful or inappropriate content from being outputted? By having vendors answer these questions, you can quickly see which ones are more mature than others, and you can take a stance on where your own org's risk tolerance is when it comes to integrating AI products into your environment.
Thanks, Alan. So the final step in my three-part framework is monitoring. So I recommend asking questions such as, do you still use the model in the way that you expected when you onboarded the vendor? Have you changed the kind of data that you share with them? Has the vendor alerted you of any sub-processors that worry you? Again, this is a very similar inquiry to what you are probably already doing through your procurement process. Now, I'm going to pass it over to Alan to talk about Grammarly's journey to compliance. Alan, over to you.
All right. So you know what to keep in mind and what questions to ask your vendors. Now let's give you an example of what this looks like for an AI company that wants to show a strong compliance posture to their customers using Grammarly as an example. If you remember the earlier timeline slide showing AI regulations and frameworks, the compliance teams partner with legal to stay current on what regs are here and what is coming. But again, it's the frameworks and standards that help formalize the regulations into something operational for the company. So when the NIST AI Risk Management Framework and ISO AI Risk Management Guidelines came out in early 2023, we quickly adopted them and started building out our AI processes and controls, integrating them into the same consolidated compliance framework as our other security and privacy certifications. And when the ISO 42001 standard came out in late 2023, we formalized the controls and are on track to achieve certification of the world's first global AI management standard early next year. Some of the key players you'll see here at the bottom that are involved in this is obviously legal and GRC, privacy and security teams, and responsible AI teams. We've been an AI company for 15 years, so we've had a responsible AI team for quite some time now, and it helped a lot to kind of fill in the gaps and bring us up to speed to meet these AI regulations. But it doesn't end here either, right? So there's constantly other frameworks and tools popping up as well. The ISACA organization put out an AI audit toolkit recently, and MIT also came out with an AI risk repository that seems pretty comprehensive. So it's an ongoing effort to keep watching out for what's new and relevant to your org, stay on top of this rapidly evolving space.
That's right, Alan. So security and compliance is at the heart of everything that Grammarly does, whether it is developing our own AI communication assistant or working with our over 70,000 professional and enterprise teams. Grammarly has over 15 years of expertise providing AI-powered communication assistance that is built on best-in-class infrastructure with the largest portfolio of enterprise-grade attestations for an AI writing assistant. And as you could probably guess, we'd love to show you how Grammarly can support your business. So you should see a poll on your screen. If you would like to learn more about how Grammarly can help your organization adopt Gen AI safely, securely, and at scale, please go ahead and select yes in the poll. And while you are all answering the poll, we can turn it over to the Q&A portion of today's webinar. Thank you so much. So many people submitted questions in advance, and I understand that we're getting some live right now. So we'll start, Alan. What AI compliance policies are necessary for employees?
Yeah, so it really depends on if your organization is just a user of AI products or a builder or developer deployer of AI products. So I'll start with the easier one for now. If you're just a user of AI products, tools like Grammarly, tools like ChatGPT, at a minimum, you should probably have an acceptable use policy, right? So most organizations have an acceptable use policy already for the tools and devices that they're using, but highly recommend you also have a generative AI or AI acceptable use policy as well. So all of your employees and contractors know what is acceptable use, when they're using these tools. Most leaders will not want their employees kind of putting sensitive information or super confidential information to tools that are not approved, that have not been vetted, for security, privacy, and AI compliance. So that's the number one policy for general employee use, of AI tools. And then if your company is a builder or deployer of AI products, then your policies are going to get a lot more, right? Because that's when you're getting into making sure that engineers are developing, model training, model developing, testing their products in a way that's compliant with all these standards and regulations. So you'll probably have, product development policies that talk about all the things that they need to do when designing, testing, and deploying these AI products for general use.
Next question. What do communicators and marketers, especially those utilizing generative AI, need to watch out for with new AI regulations? I love working with our marketing team, so I can take this question. First, I would think about trademark concerns. Did your software generate a logo or a name that infringes someone else's trademark? Do not assume that the software has done a knockout search for you. And then I would consider copyright issues. Can you be sure that the text that Gen AI tools create don't infringe on someone else's copy? Does your contract with the service have them indemnify you if the output is infringing? This space is in flux, so do keep an eye out for forthcoming guidance from the US Copyright Office. And while it's not a legal concern, Marketers need to be aware of the many AI tools that their brand messaging passes through, all of which can slightly change the tone, clarity, and on-brand voice of content and communications. So tools like Grammarly that are present wherever teams write help ensure the consistency across communication. Next question. What is being done to identify and mitigate bias in AI algorithms? Alan?
Sorry, yeah, I'm just trying to look at the other questions that are coming in. Yeah, so identifying and mitigating bias in AI algorithms, this varies from company to company and depends on whether the vendor is building their own models and or is building on top of third-party LLMs. Grammarly, we do both here, and we have a whole dedicated RAI team that is deeply embedded in product development and maintenance. Using a combination of technologies, we filter AI and natural language suggestions to reduce risks in input and output. We have a proprietary content filtering and moderation solution that's both algorithmic and ML based, designed to limit instances of higher risk language that could cause harm or result in hallucinations. And and we also design and develop products with a large team of analytical linguists who apply research and expertise to minimize bias and also apply user feedback.
Well, next question. Where is the best source to find out about emerging laws and standards? I'll take that one. I have a favorite weekly podcast. It's called Waking Up with AI. It's on Spotify, and every episode is under 10 minutes. The IAPP, which you might already know from the data privacy world, they put out several newsletters. Um, on LinkedIn, Grammarly puts out an RAI newsletter, a responsible AI newsletter, and we can share a link to that in the chat. There's also general LinkedIn groups I would just recommend perusing. But I'm super interested to hear other favorites after this webinar. So please let us know if there's others I missed. Okay, next question. As a current Grammarly customer, I am concerned with how Grammarly is using my data. Is it being ingested into its AI platform? And what guardrails are in place to keep my company's proprietary data safe? I am hesitant to roll out Grammarly to my team. Alan, up to you.
Awesome. This is a loaded question, right? But it's a discussion I have often with prospective customers, mostly on the InfoSec side and with the CISOs. Um, First off, it's important to recognize that number one, we don't sell data at all. We just kind of use it to deliver our services, and it's also important to recognize that Grammarly for individuals is a very different product offering than Grammarly for business or Grammarly for education, which are enterprise offerings. So the enterprise offerings are managed by admins at each of those companies and allow for several security related features to be enforced centrally for the entire organization or institution, as we call it. So these admins can control where and when Grammarly is running. They can turn on features to prevent sensitive information from being sent to Grammarly. And by default, we do not use customers' user text to train our models at all. And this extends to our third-party LLMs as well. This is the point that Scout made earlier, where you're only as good as the agreements that you have with your third-party LLMs. So we have contractual commitments for them to not train their models on data we send to them, nor store anything on their end. And finally, there's all the good stuff that's covered in the SOC 2 and ISO certifications related to security and privacy, such as encryption, multi-factor authentication, strict access controls, things like vuln scans, penetration tests, incident response, all the typical stuff that is covered in those security standards and certifications.
Great. Next question. Oh, we got this question a lot. What do we need to know about the Biden executive order and how does it compare to what the EU is doing? Good question. So the key difference relates to the purposes behind the law. So you remember that the AIA in the EU is all about keeping consumers safe. The Biden executive order is different. The Biden executive order is about the US protecting our national secrets. So, for example, let's say you sell software to a US agency. Let's say you sell software to the US Navy. You sell software that's going to help them maintain their maintenance schedules and procedures. The executive order would get at this use case. So you, as a government contractor, would not be able to train your models on the inputs that the Navy provides about machine performance or schematics, because that is the country's secret information. So some people think that the executive order is actually more stringent than the AIA, but it typically will only apply to these government contractor roles. Okay, next question. How do you actually assess the compliance of your vendors? Alan?
Yeah, so again, GRC team is one of the key reviewers as part of the third-party vendor review process. So at Grammarly, several teams are involved. First, we get an idea of what data will be processed by the vendor and what other systems it'll be integrated with, and assign a risk classification. I think you brought up the example earlier as like financial company versus using it for marketing purposes, like very different risk levels, right? So the risk classification determines how strictly a review will be performed. And then we usually send them the questionnaire to fill out afterwards, right? So different teams check different things. Privacy team will want to understand whether personal data will be processed and what the retention periods of those are. Security team will want to validate things like single sign-on, multi-factor authentication are available, and whether their general security posture is healthy or not. Compliance team will review audit reports and certifications, kind of like those proof points to show that they're doing kind of what they're claiming that they're doing, which are all the right things. And legal will be reviewing the legal contracts such as the data processing agreement, the DPA, and other service agreements. If there are any AI features, our responsible AI team also reviews the questions related to model training, performance accuracy, bias, harmful contact management, like all those things we mentioned on the other slide.
Yeah. Okay, next question. I'm currently doing a review of an AI app. Please elaborate on why we want to ensure the vendor has an enterprise agreement with the LLM. Okay, good question. So typically, enterprises, big companies, have more bargaining power than an individual signing a terms of use. So if you want to embed OpenAI into your product, or if you're bringing in a vendor that has OpenAI embedded into its product, you want to make sure that they have an enterprise level agreement with Azure or with OpenAI, because they're more likely in that agreement to have gotten representations and warranties around confidentiality, non-use of your data, zero data retention. And so asking questions about whether there's an enterprise license acts like a proxy of getting at the relationship between the LLM and the vendor that you are purchasing from. Okay, last couple questions, and thank you so much for submitting these. Alan, at what stage of the procurement process do you start asking these types of questions? If the team just wants to sign in for the free trial, do you still go through all the stages?
Yeah, that's a great question. Sitting in security and compliance, we don't really necessarily pay attention to how much something costs. We're more concerned about the risk to the organization and protecting our information and our customers' information. So even if it's free, sometimes these free ones are more risky, right, than the non-free ones. So we don't really exclude or put free ones in a different category, or free trials in a different category when it comes to doing the vendor assessments and doing the review. So same thing. We just first want to understand what is the vendor service doing, what kind of data is flowing through it, what kind of risk level is there to us and to our customers by introducing this new vendor service into our environment. Is it going to touch customer data? Is it touching employee data? So you still want to kind of get that general understanding up front. And then from there, once you've classified it into the different risk classification levels, then you kind of go down the path of, okay, how is this like a very robust review that we need to do for like a trial? Maybe there's ways you can kind of put guardrails in place to reduce the risk, um, and not integrate it with so many systems to just kind of try it out.
Yeah, love that. I think we have time for two more questions. So, does the EU AIA impact US companies? Great question. Yes. So I would think of the AIA similar to the GDPR. The GDPR gets at, whether you're collecting the personal data of EU residents and devices and households, um, and if your app or service is made available in those countries. The AIA is similar. You can be situated here in the San Francisco Bay Area, but if your service is accessed in Europe, you're collecting information from Europeans, you can certainly trigger the requirements of the AIA, even if you're not in Europe. Okay, last question. Regarding the eyes off point from a previous slide, at Grammarly, does the company treat data differently between personal and corporate/business accounts? Alan, you want to take the last one?
Sure. So as I kind of mentioned before, Grammarly for individuals or personal accounts versus Grammarly for business or Grammarly for education, which are enterprise accounts, are different in the fact that the enterprise offerings have the admin security features and controls available to them to kind of enforce across the whole institution. But when it comes to like eyes off, the comment here I think is eyes off. Who within Grammarly, are there any engineers that can access customer user data? It's all handled the same way. So if you look in our audit reports, uh, Grammarly for individuals, Grammarly business, Grammarly for education, they're all scoped the same way with the same controls. And at Grammarly, there are no engineers at Grammarly that have any persistent access to customer data at all. In addition to that, we have mechanisms to de-identify data as much as possible, so that data minimization kind of concept that I was talking about earlier, we de-identify data as much as possible. So the data that we do store, the minimal data that we do store, is not kind of personally identifiable to a specific person or company. Um, but yeah, we don't treat in terms of access controls and who has access to customer data and like encryption and all that kind of great stuff that falls within the SOC 2 controls. There's no difference between personal and these corporate business accounts.
Okay. So I think that wraps up the Q&A. And again, thank you for people who submitted those questions. So next steps, please check your inbox. We'll be sending you a recording of this. If you have questions, you'll see a link to the survey in the chat. And we hope you stay in touch. We have so enjoyed getting to take the time to speak with you all today. So thank you everyone from tuning in around the world. And I hope this was helpful. Thank you.